finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected.
Sige pa.
Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state warranties. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state warranties. The appeals chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58(1)(b) of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58(1)(b) of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination.
From Spain.
Not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all the three risks under Article 58(1)(b of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release. The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected. Finally, the appeals chamber notes that the pretrial chamber reached its conclusions in relation to the risks enumerated in Article 58(1)(b of the statute on the basis of a comprehensive assessment of the information before it. In the present case, having rejected the three grounds of appeal presented by the defense in the appeal brief, the appeals chambers unanimously confirms the interim decision. This brings us to the end of the summary of the appeals chamber judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
Denied? Denied. Hindi pa rin binigay, the decision? Ayan, denied.